Are we on? Good evening. Welcome to Planning Commission meeting. Today's date is July 20th, 2011. Roll call, please.
Planning Commissioner Astorian.
Here.
Planning Commissioner Landrigan.
Here.
Planning Commissioner Sheets.
Here.
Planning Commissioner Yesayan.
Here.
Chairperson Lee.
Here. Report regarding posting of the agenda.
The agenda for this meeting was posted on Wednesday, July 13th, 2011 on the bulletin board outside City Hall and on the city's website.
Can everybody join me in a pledge of allegiance? I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Next item is approval of minutes. Can we get a motion and a second for the July 6th regular meeting minutes?
I move approval of the minutes.
Second it.
Okay, we have a motion and a second. So minutes has been approved. I'm looking for oral communications. I don't see any. So we'll move right into the zoning appeals. Now, before I do that, I'd like to switch some of these projects around because some of them are being continued. So unless any commissioner has a problem here, I'd like to have Planning Commission item A, which is 2246, 2248 Raphael Terrace project for continuance to be considered. And the second item is Linda Vista is being also asked to be continued. But we do have speakers here that turned in the cars, so we will address that when we come to that Linda Vista project, and then we'll probably go into the regularly scheduled zoning appeals project. Do we have any problem? Yes?
No. Would you like me to make a motion to continue?
I'm sorry. Chairman Lee and Commissioners, the reason why 3431 Linda Vista Road is being requested for a continuance is because the fire department would like some additional time to review the project to make sure that the residents and the whole development is made as safe as possible.
I think you need to take action on Raphael Terrace first.
That's what I was going to do.
Right.
Thank
So,
you.
so we're on the Raphael Terrace project.
I'd like to make a motion that Raphael Terrace, old business, item number A, tentative tract parcel map number GLN 1625 be continued to, did we decide August 3rd?
August 3rd.
I'll second it.
Okay, we have a motion and a second. Roll call, please.
Planning Commissioners Astorian.
Yes.
Landrigan.
Yes.
Sheets.
Yes.
Yesayan.
Yes.
Chairperson Lee.
Yes, so 405-0. Tentative parcel map number GLN 1625, 2246-2248, Raphael Terrace has been continued till day certain, August 3rd. Okay, next item is Linda Vista project. So, Mr. Dong.
I apologize for that interruption. Again, Chairman Lee and Commissioners, the fire department is requesting some additional time to review the project further to make sure that the residents as well as the project as a whole is made as safe as possible from the fire protection perspective. Therefore, staff is requesting that this appeal be continued to a date certain, September 7th, without further notice.
Okay, I guess we could, because we have people here on this project, we could open the public hearing and hear the people and continue to, you can continue to come on the continuous date to also express your concerns. Or we can continue this case and then you can all come back on September 7th. So I guess first, I'll ask our fellow commissioners, do we have any problems with continuing the case till September 7th? Okay.
No, do you want to ask for a show of
Yeah.
hands?
Well, I would be okay continuing it, but I think, we would also want to hear.
Okay, so for the For the public who wants to make comments, would you like to make comments at this time, or would you like to wait till September 7th? Wait? Okay. Continue it? Okay. So I'd like to need a motion, and yes.
Mr. Lee, I'd also like to add to that I spoke with Mr. Foya about some items that I thought were missing from this packet that I hope that he conveys to the applicant also.
Yeah, they have been conveyed.
Okay,
Okay.
thank you.
So may I have a motion, please?
I move that conditional use permit number P, CUP 2010-020, and standards variance case number PVAR 2010-009, item number B, be continued until September 7th, 2010, providing the items indicated.
A second. Did you say date certain?
I said September 7th.
Oh, certain. Okay.
Is that all right?
Now we have motion and support. Roll call, please.
Planning Commissioners Astorian.
Yes.
Landrigan.
Yes.
Sheets.
Yes.
Yesayan.
Yes.
Chairperson Lee.
Yes. With a vote of 5-0, the item number B, conditional use permit number P, CUP 2010-020, and standards variance case number PVAR 2010-009 has been postponed, continued till September 7th,
Without further notice?
without further notice. Thank you. Okay, then next case we have is the zoning appeals, item A, standards and setback variance case number PVAR 2010-014. Now this case has been continued from last hearing, and the public hearing is closed unless we have Commissioner Schiss that may have some questions regarding this case. We'll open it just for that purpose. Do we need the staff report on this again, or?
Mr. Chair, my suggestion is maybe a very brief summary of where it was. If Mr. Sheets has questions,
Sure.
that would be appropriate too.
Okay, Mr. Joe.
Well, first, I just wanted to, since the last Planning Commission meeting, staff has received further testimony from the public, Laura Moore. Also, staff had received earlier this, just late in this afternoon, additional exhibits that do not match the public notice. The public hasn't been able to review to comment it, but since the public hearing is closed, we wouldn't be able to accept it as of right now. But I think where we left off from the last time, from the last meeting, there was a request for the fifth planning commissioner to be present to review the exhibits and perhaps give his thoughts and so forth. But was there any details specifically that anybody would like to ask staff so that I can fill it in, or?
And actually, before we begin, I also want to make sure for the record that Mr. Sheets did review the tape from the last meeting, just to make sure so he can participate in the hearing.
I did review the tape.
Okay, thank you. Commissioner Schiss, do you have any questions?
I have a question now. What does the additional plans do to the process?
Well, essentially, they were submitted just, I think, today, 11th hour today.
So they don't have
They're
any
not part of the
bearing, they're
record.
not
They
even
don't
part
have
of
no
it.
bearing on the commission's decision.
Do applicant have choice of, for the purpose of reviewing the submittal to continue this case? Or?
The commission could always continue it and continue to date certain, and then give everybody that was participating in the hearing an opportunity to review those plans before going forward. But I'm a little hesitant to, really hesitant to have the commission review that plan today, because it just came in, and
Right.
people who maybe came here the last time didn't stay under the assumption that it was really going to be just about
It wasn't available to the public or anything.
right.
Thank you, Mr. Garcia.
Well, if I may, Mr. Chair, I have a question for
Yes, Mr.
Mr. Garcia. They have made some changes to their plans. Is that what the case is? And because there's not been enough public notice, that's why we cannot consider. Is that where it's at?
Essentially, yes. And in fact, I haven't even really reviewed the plan either. It came in, and the public wouldn't have the opportunity to review it before the commission has had a chance to look at it and weigh in on it. Essentially, any new document or evidence that would come in that might affect your decision everybody from the public has to have the opportunity to look at that to see what it is you might be relying on before you make your decision and then comment on it. And the concern is that the public that was here that spoke on the project the last go-round did not have a chance to look at that plan and comment on it to the commission.
Let me follow up with you, Mr. Garcia. There were a couple of motions made in the last hearing that had to do specifically with the change of plans. Even if these fall within that purview, we cannot hear it.
Well, you can discuss anything that's within the notice. My concern is that with the plans, an actual physical plan, might be something on there that somebody would catch that, maybe the commission wouldn't catch. And again, it's really about the public that was here that spoke the last time not having an opportunity to look at that evidence.
Public also, they were all supporters of it who did speak. And then we do have new evidence that people always come up and they bring it. So what makes this different? Is it really substantially different?
Yeah, because essentially we closed the hearing at the last meeting, and so it was really for at this point for the commissioners to raise questions, maybe to staff or even the applicant, follow up, but not to have new evidence submitted that hasn't been considered or reviewed by anybody from the public.
Can we get an idea of what it is? I mean, what is the change?
Well, we may ask.
I don't know.
I don't even know.
Commissioner Sen,
I don't know
let me ask Commissioner Schiss if you have any questions, towards staff or towards the,
Relative
the
to my
applicant.
reviewing the tape and deliberation through that process, I have no question.
Because the public hearing is closed, so we are ready to deliver. Now, I'm going to ask my fellow commissioners if you are willing to entertain whether or not the applicant, in view of this new information, is willing to come up and ask for continuance on this case, or ready for our deliberation today.
I think we should decide that and not ask the applicant, obviously.
Okay.
I think that's not their decision.
Noted. Thank you.
Well, just my statement would be I reviewed as requested, made my notes, and I'm ready to give my thoughts on that and my decision.
Okay.
If the commission chooses to go that way.
If I may ask,
Yes.
Mr. Chair, we're still open to ask questions from the applicant if we need to, or
No, that's closed.
That's correct.
But we could choose to open it if that's what we're asking right now.
Nice.
So what are your thoughts?
If I may, look, I'd like to, my curiosity is piqued, and we're not really discussing plans in the Planning Commission. We're discussing land use issues and so forth. I'd like to see what it is that they have to say.
If I may,
Yes.
then you can move that we continue it and open the public hearing
And notify the
and
public.
notify the public and look at it at another date. But we can't really look at it or discuss it or even ask them questions about it.
Oh, hang on, I can ask questions from the applicant, yes or no?
Well, there's a line here that you really want to be careful across. I mean, it was the main purpose would be for Mr. Sheets to ask questions because he wasn't here the last time.
Okay.
If he had questions. And again, I would agree with Commissioner Landrigan that if the commission really wants to see the plan, then I think that the commission should continue it and allow everybody from the public to look at it.
Well, Commissioner Strain, are you, you say your curiosity has picked up. Are you then entertaining a motion to continue this case, to look at those plans?
My curiosity was just quailed. So I don't. Squelch.
Okay, so then we're ready to make the deliberation then.
I'm ready to make deliberation based on what we heard last. I don't know
Right.
if anybody else is, but I'm thinking about one thing. If there is new evidence that is going to make a difference, at least we need to. It's again. I don't want to. It's doing it half-heartedly about, if there is new evidence, we need to hear it, in my opinion.
We agree. But it's not appropriate to hear it tonight.
Right. So then you need to make the motion.
It has to be
continue with
posted.
that.
We all have to review it and just come back and open the hearing
And it becomes
and do
a
so.
public hearing and not a continuation.
And when would this come back, Ms. Stadler? This is the third time that this thing is...
Well,
Well, you would need to set a hearing date. The next meeting we have is August 3rd.
And it's pretty full.
Perhaps maybe I can ask for a clarification question with other staff. Would the notice have to be updated with the new numbers and so forth? Like not much is changing, but just to update everything.
Apologize. On this particular, as far as what I understand, if it's a revised plan, it might be smaller, but again, it's new evidence. It's probably appropriate for the commission to continue it to a date certain, and then for the staff to notify everybody that commented on the project or appeared at the hearing that there's been some new evidence and the commission's essentially reopening the hearing.
I think that's a good idea. Yeah. And then we can decide if we want to go with the old plan or...
I'll entertain the motion.
How do you do this?
you moved.
You move.
I move what?
Continuation.
Oh, I see.
Continuation.
So I move to continue
And then you read
the case under, in our agenda, under
Zoning appeal.
case number, let me find out the case number.
Front page.
Here, this one.
I move to continue the case the case number PVAR 2010-014 to date certain for property most commonly known as 1017 Cumberland Road.
For August 3rd, right?
And to open the public hearing.
And to open the public
And to
hearing.
accept the new exhibit.
And to
for
accept the
public
new
review.
exhibit.
Okay.
Second.
Second. Okay. Roll call, please.
Planning Commissioners Astorian,
Yes.
Landrigan,
Yes.
Sheets,
Yes.
Kesayan,
Yes.
Chairperson Lee.
Yes, with a vote 405-0, the zoning appeals standards and setback variance case number PBAR 2010-014 has been continued till date certain, August 3rd, with the public hearing reopened and the evidence submitted. Okay, then we're ready to move on to case number, conditional use permit number PCUP 2011-006, location 117 South Louis Street. Staff report,
Meeting's
please.
very efficient.
Yes, Chairman Lee, and forgive me, is the microphone? Okay. Chairman Lee, Planning Commissioners, the case before you is an appeal of an approved conditional use permit to permit banquet hall activity and service and consumption of alcoholic beverages at an existing multi-purpose cultural arts center located at 117 South Louise Avenue. This otherwise known as the Armenian Society of Los Angeles, ASLA. The conditional use permit for the banquet hall activities and service and consumption, not sale, of alcoholic beverages at ASLA was approved by the planning hearing officer on May 20th, 2011. There were 28 specific conditions of approval regarding the case, one of which dealt specifically with the hours of operation. The approval was then appealed by the adjacent property owner, Glendale Presbyterian Church, and the appeal was specifically based on the hours of operation on Sunday mornings. Since that time, both parties, both the ASLA and the Glendale Presbyterian Church, have met and have agreed to modified hours of operation. Those hours would be 10 a.m. on Sunday mornings only, and so they're only modifying the start time on Sunday mornings. This was detailed in a stipulated agreement that you received as part of your packet. Staff is recommending that the Planning Commission uphold the planning hearing officer's decision to approve the CUP with the modified hours of operation for Sundays only. That's staff's presentation. I'm available to answer any questions you may have, and attorneys representing both the ASLA and the Glendale Presbyterian Church are in the audience.
I do not see any the public comment card here, so
They just said that they would be available to answer any questions you may have. So,
Commissioner Landry.
I move approval.
Sorry.
I have some...
Oh, sorry.
I'm sorry, I needed a little bit of housekeeping. I just realized I would request that two motions be, there's two CUPs, one for banquet hall and one for alcohol, that they be broken up into two separate motions. And the condition number 28, which has to do with the authorization, apply only to the alcohol CUP. Essentially, what was provided is a motion which approves the banquet hall CUP and the alcohol CUP with findings for each use. And I'd request that the Planning Commission adopt separate motions for each one of those uses, and that the conditions of approval for the banquet hall CUP not include condition number 28. So essentially, both motions would include all of the same conditions, except the banquet hall CUP would not include condition number 28.
28, okay.
Actually,
Oh, I'm sorry.
forgive me,
Sorry, I'm looking at the one that's in.
yeah, Mr. Garcia, actually, the 28 conditions were for the CUP for both banquet hall and service and consumption of alcoholic
No,
beverages.
and I understand that. What
And
I'm-
the findings were separated.
Right, and
Fine.
I understand that, but what I'm saying is that we cannot impose the condition number 28 on the banquet hall use, but we can on 27 on the alcohol use. So I just want to. That's not too complicated.
Okay, so then the item number 28 will not be applicable to banquet use. Is that-
And I'll read what I have, at least in my packet, that the authorization granted here shall be valid for a period of 5 years until June. And let me explain the reason for that. And I'm sorry, but someone from my staff should have explained this. When you have a conditional use permit for a use that involves the construction, which involves a use essentially, once that use has been granted a CUP and has been relied upon and used, the standard for requiring renewal is different. Essentially, the cities can't require renewal for a use where there's been development and it's been relied on. Alcohol is a little bit different. The court's treat it differently. It's not a vested right. You essentially have the right to condition it until we have the right to condition it with conditions that require that it be renewed every so many years.
So, Mr. Garcia, just for the housekeeping purposes, can we then, because it has the same number, can we go, number A and B?
That'd be appropriate, yes.
Okay.
Yeah,
Okay,
continue.
so just for clarification purposes, also for staff's clarification, the condition 28 refers to the expiration of the conditional use permit. And according to what I'm hearing from Mr. Garcia, the conditional use permit for the sale of alcoholic beverages would be granted a 5-year valid time period, at which point in time the property owner, the operator, would have to come back and obtain a conditional use permit for the service and consumption of alcoholic beverages. However, the banquet hall use would be granted approval in perpetuity.
Correct.
Is that correct?
And it'd be subject to normal revocation
That's correct.
if there was a violation of the conditions.
Commissioner Landrigan?
So I'd like to finish my motion.
Okay.
May I?
Yes, please.
Staff?
Yes.
Thank you.
I apologize for the confusion.
Thank you. I move approval of conditional use permit case number PCUP 2010-001A for alcohol use at the banquet hall, which includes the 28 conditions.
Second.
And excuse me, yeah, the date in that, I believe that you have is June 7th. So I don't know if you want to change the date to 5 years from today.
Correct. It would be
So July 20th.
From July 20th to amend my motion.
Now, which is correct? We have PCUP 2010-001, and we have 2011-006.
the correct one is 2011-006. That is the correct one.
To
I will
amend.
fix that also.
Yes.
And Mr. Sheets, is that all right?
I second.
We do have a motion on the floor.
And I
Do we
second.
need to have continued discussion from staff?
Okay, so with that corrected PCUP number, we have motion and a second. Roll call, please.
Planning Commissioners Astorian,
Yes.
Landrigan,
Yes.
Sheets,
Yes.
Desayan,
Yes.
and Chairperson Lee.
Yes. So with the vote of 5-0, conditional use permit number PCUP 2011-006 with the separate CUP conditions for banquet use and alcohol consumption is approved.
Do we need a separate
Need a
motion,
separate
though,
one.
for the next one?
Oh, okay.
Yeah, this was A.
I apologize, okay. So that was for the banquet use, and I'm sticking
Alcohol.
That was
alcohol use, alcohol use, and then I'm seeking the motion for the banquet use.
I'll make the motion, or at least I'll attempt. So I move to approve conditional use permit 2011-006 for the continued use of a banquet hall for property most commonly known at 117 South Louise Street. Do I need to add anything else to it?
Actually, it's not a continued use of a banquet hall. It would be a new use.
Yeah, it's continuous.
That you would have to say
Use.
with 27 conditions.
With the conditions attached.
27.
And I redact the continued use.
It would be for a new banquet hall. It's a new,
banquet.
not a continued use. So yes, with 27 conditions, correct.
With the 27 conditions attached.
Correct.
So with the corrected comment, seeking support.
Second.
Second. Roll call, please.
Planning Commissioners Astorian,
Yes.
Landrigan,
Yes.
Sheets,
Yes.
Desayan,
Yes.
and Chairperson Lee.
Yes, with the vote of 5-0, conditional use permit number PCUP 2011-006 for banquet use with 27 conditions is approved.
Thank you.
Next item is our zoning code amendment, PZON 2011-008. Who's,
Thank you.
Bye-bye.
Yes, sir, I'll give the staff report on that.
Mr. Foy?
As you know, the state legislature recently passed a couple of bills which were signed into law by the governor that would affect the possible existence of redevelopment agencies. One bill eliminated redevelopment agencies, and I think a companion bill said that they could remain active so long as there's a certain shifting of the monies from away from the redevelopment agency to other taxing agencies. Both of these laws, I believe, have there's been a litigation filed contesting their validity. So we want to be able to ensure that projects that come to us in the redevelopment project areas will be able to continue their approval process no matter what happens in these sort of uncertain times. And because of that, we went through the code and found places where the redevelopment agency is the approval authority for various kinds of permits, for design review, for parking exceptions, for certain kinds of variances. And this is just a contingency plan that says if the redevelopment agency is eliminated, then those review authorities for those various kinds of permits will be transferred to the city council. So, of course, here in Glendale, the city council acts as the redevelopment agency, so it's really it's the most minor of format changes. There's really no change in who the people are that will be reviewing. There's no extra steps that an applicant has to go through or anything like that. It's just a name of whether we call them the council sitting as a redevelopment agency or the council sitting as itself. And these are just contingency plans. Even if the redevelopment area, even if the redevelopment agency is eliminated, my understanding is that redevelopment project areas will continue in effect because there will be some sort of successor agencies to deal with all the financial obligations that have been made for the future. So the redevelopment project areas will stick around even if the agencies are eliminated.
Any questions?
It's about as sensible as I can make this difficult.
Commissioner Schitz?
Is it possible that with the litigation, there would be a retroactive component that would make that not happen? As far as going back and affecting the projects that are already underway from redevelopment?
Are you referring to the redevelopment projects?
Yes.
Yes. Essentially, this is, like as Mr. Foy explained, this is just a contingency plan. The legal cities and the California Redevelopment Association filed litigation yesterday or Monday. And if this litigation is ultimately successful, then essentially that redevelopment law will be invalidated and just be in the same, we'll be in the status quo, same position we are. This is just an event that the agency is eliminated and that we need to put that review authority with somebody. Just by way of background, we did, the city council last night actually did adopt the ordinance to sort of opt back in.
Right.
There's a financial cost to the city for doing that, but the council wanted to go forward and keep the agency open. But just in case at some point the city can't continue to make the payments that it has to make on an annual basis, we'll have this sort of contingency plan in the event the agency is eliminated. Because essentially what happens is that the city at some point decides not to make its payment, at that moment the agency is abolished. So it's a very, very strict, piece of legislation. So we want to be prepared in the event that the agency is ever eliminated. And actually, and if we're successful in the litigation, quite frankly, it wouldn't be surprising if the legislature tried to do try to find another way to do this. Right. So we just want to be prepared if it happens.
Thank you.
Commissioner Stroyan, you have...
Just a couple of questions. Even though that you have chosen to attend in the WARP program, still these revisions are needed, right? Because it may. Yeah.
Again, it's just in the event that we're.
And then on the ordinance page, there is right in the middle of the paragraph, there is a mention that the city or agency may require that the agreement provide public benefits, include the sharing of revenues from the signs permitted by this chapter. Can somebody explain to me what revenues from signs is?
This is a red line version of the existing code, so those provisions are already in the code and they relate to the overlay zone, the signage overlay zone that apply to the Americana and the Glendale Galleria.
Right.
So that was back when that was adopted last year. That was part of that package, was that if there's ever signage, that there has to be these community benefits agreements that are negotiated before they put their signs up. So that's already part of an existing program.
So there is no language change in the code with the stipulation that the council now can take the decisions as far as the agency is concerned if the agency goes away.
Well, there is one other kind of house cleaning topic that we included in this, and it relates to thresholds for design review, both in the redevelopment agency as well as in the downtown specific plan areas outside agency areas. The downtown specific plan and the downtown specific plan has almost all of this central Glendale redevelopment project area. It has about one block of the San Fernando Road Corridor redevelopment project area, and it has a bunch of blocks which are not in either redevelopment project area. They're just, DSP is simply their zoning. So what this relates to is we now have a provision in the code and in the agency's guidelines which say that projects under 10,000 square feet are exempt from design review. Now, as you know, when we say something is exempt from design review, it doesn't mean that no one is looking at it. It means that staff is looking at it and deciding that the project, as it is, does not need to go to a public hearing. Code establishes certain thresholds when you're greater than that, then you have to go to a public hearing before the design review board or before the redevelopment agency or whomever. But if you are below the threshold, which in this case is 10,000 square feet for these areas, then staff looks at it and decides, is there anything so objectionable about the project that it does need to go to a public hearing? We can kick things up, so to speak.
So does that mean, since this is in the downtown redevelopment area, if it is over 10,000, does it go to design review or does it go straight to redevelopment?
It goes to redevelopment. The redevelopment agency
doesn't go to design review.
No, right. In the redevelopment areas, for projects which require a public hearing, the redevelopment agency is the review authority for design review.
Okay, so that's what you mean when you say design review. It's really redevelopment.
But yes,
Yeah.
or it could be the design review board for areas outside the project areas.
It is the design review process. It's just not going to the board.
Right, I
The
got it.
agency's acting as the
Okay.
review board.
Right. Okay.
So is that why this paragraph F, your page 21, was eliminated, and instead, in the next page, you had D and B that were added?
Now, let me get page 21, please.
Page 21 of your report, it's under the authority.
Right. Yes, that's right. And I want to give one further nuance in this, is that generally speaking, when we say something is exempt from design review, it's usually a pretty quick check. But in these areas, if a new building up to 8,000 or 9,000 square feet can be built without having a public hearing, the staff is still doing quite a bit of work on that. We call it administrative design review. So what this code section does is just to recognize that that is actually kind of a separate process and a simple exempt stamp at the counter. And they still don't have to go to a hearing, but we're just kind of codifying what really is our existing practice. An example of this is the Glendale City Employees Federal Credit Union building going up about a block from here. And it's a new building of several thousand square feet, and really, staff spent as much time negotiating with the architect, doing plan check as any other new commercial building. So this kind of recognizes that
Staff's
there's really
like
a
the
third
design
step.
review board for under 10,000 square feet.
Commissioner
fine
Landrigan,
with
you had
us.
a question?
Yes, I have a question. I've read through this and I've looked at the changes, and on page 7, where it has new development, and in 2 other places, it states that this is final review by the Glendale Redevelopment Agency. In the event the redevelopment agency is suspended or eliminated, the review authority shall be the city council, pursuant to the policies adopted by the city of Glendale or Glendale Redevelopment Agency. And it's removed specifically the design review guidelines. It's put in place a term policies, which I think is awfully broad. And in the staff report, it specifically indicated that it wanted those design review board guidelines, design guidelines that were adopted by the Glendale Redevelopment Agency to hold sway over this, and yet it just calls them policies. I have a concern that it's been distilled to that word. And it's also stated as such on 22, on item number 8, and on page 23, under authority on IA, where it says the process for design review, including any consultation with the design review board, shall be reviewed in accordance with policies adopted by the city. So there are no longer any design review guidelines mentioned in this whole document that hold sway. And I think that's quite interesting, and I'd like to know why.
Okay.
And what are the policies?
Okay. In design review, the design review chapter does have standards under which things are to be reviewed. So that, in a sense, are guidelines. And the zoning for the central redevelopment area, which is almost completely contained within the DSP, would follow the review, the design guidelines in the downtown specific plan. If you look at what are now called agency guidelines, they actually have no guidelines in them for design at all. They really are just submittal requirements, and they briefly describe the process. So I believe at one time there were design guidelines
A beautiful
attached to this
booklet.
document, but they have since been supplanted by other well, yeah, I mean, the DSP primarily, as well as the design guidelines that were built into the San Fernando rezoning, which occurred about 8 or 9 years ago. So, and those are all, there is protection, there's assurance in our code that those guidelines for San Fernando Road and for the DSP will be implemented in the design review process.
Should these items say that?
So it's part of Chapter 30.47.
Right, but the way they're stated now, it doesn't direct your thinking to that. It kind of sounds like it is diluted, and it's like whatever the policies are, but not specifically the policies to that particular redevelopment.
I think Commissioner Landriger's issue with this is, substituting design guidelines with just policies.
Yeah, I mean, if there are design plans for San Fernando Corridor, then and for the other particular areas, then it just needs to state, follow the design review guidelines for those particular developments or redevelopment areas.
Whether it's
Something to that effect.
Right.
Okay, may I suggest perhaps then we add, if you see this piece, which is called Glendale Redevelopment Agency Design Review Submission Requirements,
Right?
where we have added new language about projects shall be reviewed in accordance with section 30.47.030.
Can you tell us what page of that? The first page?
It's the first page of our of the revised submittal requirements, what we're calling submittal requirements, that follows the ordinance.
Okay.
Have you provided us with that section of the code?
Is it the last?
I'm so-
No, it wasn't.
Yes.
so-
Right after the
Okay,
motion?
what I'm about to explain is that is a section which describes review authority. And maybe I think the point you're getting at is that we should include another reference to the section of the design review chapter that talks about what standards they're reviewed under, which is the following section, 30.47.040.
All right.
And which you actually do have a copy of here. It starts on page 23. And that's the authority section. It starts on page 25. And you will notice at the end of that very first paragraph, it says, within the DSP zone, all design reviews shall be subject to the guidelines and standards established in the downtown specific plan. Then for when you're not in the downtown specific plan, the rest of the chapter gives the standards by which the design review board
Yeah, it's clear it says that.
should judge things. So is that the sort of direction you were looking for? Is that
As
just-
opposed to just using the word policies? Yes, because my other concern is clear direction to an applicant so that they have a chance of success. And policies is a little loose. And I think that the clearer we are in giving individuals who are working with the city, especially when it's an exempt project in essence, that both the public and the applicant have clear idea of what the guidelines are, what the sections of the code are that govern it, because it just makes for a better relationship and a better project and a shorter timeline.
I'd like to add the thought to that piece that we're talking about. What's happened in my mind with, if you see the policy statement as maybe diluting the clear direction or specific information about the standards. And what comes to my mind and what I thought about when you said the 10,000-foot limit, I thought, okay, and anything above that automatically goes to design review. And it almost sounds like anything below that does not. But you clarified that it could. Who makes that determination, and is there an approval level? And that's what I'm thinking. It would be the director, because that kind of dovetails off of what Commissioner Landrigan just said. If somebody comes in here thinking, oh, it's under 10,000 feet, I don't have to worry about that, and then it's done, do they know why it's done? Because if one of your staff makes that determination, then they don't know what the standard is until that determination is made and you explain it to them. So that's the thoughts that came to my mind while we're discussing it tonight. I didn't see that when I was doing my review, but that kind of makes me think if we're going to do this, I don't see a problem with it. But do they understand what's being done? Do they understand that somebody may make a decision to do design review, and who makes that, or who has the final authority? Not so much who, but who has that authority? And will they clearly understand why their project went that way and some other one may not? Now, if I'm the only one that saw it that way and that's not an issue, I'm okay with that, but that's kind of what came to mind during the discussion.
I think we shouldn't lose sight of the fact that really the intention of, with the little bit of the cleanup that was just mentioned, the intention behind all of this is to be able to transfer authority to the council from the redevelopment agency. So, I mean, and I understand the issues with the policy versus design guidelines and so forth, and perhaps, we can make that suggestion to them that they can clear that, and or at least come back with a explanation that would be considerably acceptable to you and Mr. Sheets and myself and the rest of the commission.
Commissioner Landrigan?
Or we can even direct them to make changes based upon our comments, and that we could approve it with those changes with staff's changes without it even coming back to us.
It's not even about content or intent to
I'm
me.
not here
It's
to
more about
wordsmith.
clarity.
Yeah, I do want to call your attention to, the code does have language which can warn people that their project, even if it's under the thresholds,
Okay.
might still be kicked up. And that actually
makes
is
sense.
on
It is on.
page 22. Number 5.
Okay. That makes sense.
And we use this, certainly outside the DSP, we use this all throughout the city. Generally speaking, applicants in the redevelopment areas, not only do they tend to be a fairly sophisticated bunch, compared to regular mom and pop who's never done this before in their life, but we have pretty high customer service standards with the redevelopment staff who deals with them.
Good. You did your normal good job.
Any more questions for staff?
I'm satisfied.
So maybe
You have to make a motion.
I would like to move recommendation to the city council, looking for the motion here, which I don't have, recommend that the city council adopt the proposed amendments to the zoning code concerning approval authority for land use entitlements and design review and the design review process for projects in the downtown specific plan and in the central Glendale and San Fernando Road corridor redevelopment project areas. This is item PZON 2011-008. Is that correct? Revisions to Chapter 30.47 Design Review Authority for DSP and redevelopment project areas. Revisions to Title 20 concerning contingency plans for dissolution of the Glendale Redevelopment Agency. Amen.
Yes.
Seconded.
If it's needed, okay. Got a second.
So we have a support. Roll call, please.
Who seconded it?
Commissioner Sayan.
Planning Commissioners Astorian.
Yes.
Landrigan.
Yes.
Sheets.
Yes.
Yesayan.
Yes.
And Chairperson Lee.
Yes, with a vote of 5-0, PZON 2011-008, revisions to Chapter 30.47, Design Review, Review Authority for DSP and Redevelopment Project Areas, revision to Title 30 concerning contingency plans for dissolution of the Glendale Redevelopment Agency has been recommended for adoption to the City Council.
We trust you will modify it, as we said.
With the comments that was made,
Comments.
with comments made by the commissioners. Where's my...
This is what happens when you continue cases. We have to
Oh, my
shuffle back
agenda?
and forth.
Get it mixed in there.
I think you did I stole it.
No, this is yours.
Are you looking for the agenda?
Yes, I was looking for the...
Yes.
There you go. Oh, okay, there you go. All right, with that, I guess so we're ready for planning division updates.
We do have an appeal of one of your decisions. It's at 1304 Carmen Drive. It's scheduled for City Council hearing on August 9th.
Okay.
So generally, we request that the chairman attend if possible, or if you delegate that to another
Yes.
member.
And what case was this?
This is 1304 Carmen Drive,
Okay.
and it would be at the City Council meeting, the 6 p.m. meeting on August 9th.
Okay.
I would have obliged and accompanied you, but I wasn't here hearing that case, so
Okay.
you're on your own. Okay. I knew there was a catch to it.
It's called baptism by fire.
Any other updates?
That's all the updates I have. Thanks.
So how many cases do we have for August 3rd? I think we pushed it off a few today.
Right now, we have 5 cases scheduled for August 3rd. We have 3 cases, and then that includes the North Glendale Community Plan for August 17th, and we are starting to fill up the September 7th meeting also.
Okay. Full schedule.
So you're earning your pay.
And I think there was a question about all commissioners request to be here at 4 o'clock on the
Yeah,
17th.
that won't be necessary.
Oh, that will not be necessary. So it's 5 o'clock then, regularly scheduled.
So
Did we
no,
lose some items or something?
I thought we added.
The item we were thinking of adding to that date got added to a later date instead.
so no early bird.
That's correct. Regular meeting time at 5
5
o'clock.
o'clock. Great. Okay. And any comments from commissioners?
Yeah, I have some.
Yes, Commissioner.
I noticed we didn't I guess we didn't notify residents for this last case on the banquet hall because it hasn't been passed by City Council based on our new ordinance changes where we notify apartment as well as owners. Is that right?
That's correct. The council will be considering that on August 9th.
On August 9th. Oh, so it'll be fairly quick.
It is to be
I was
hoped.
just wondering, do we have to wait until they pass it officially before notices like that have to go out, or can it be done sooner? But August 9th it's around the corner anyway. Okay. The next item was I know we're going to have some wireless things coming up in the next month or so. I had asked a while ago about like the idea of using story poles to get a better idea of these poles that are going up. And we had a case a long time ago which was a little bit hard to figure out exactly how tall the pole was just by going out and looking at it and looking at pictures only. Has there been any progress, or is there going to be any type of change in the ordinance where we can incorporate that, or maybe even ask these new applicants upcoming that maybe they can show us a story pole or something like that, so we get an idea.
Okay, well, I assume the city attorney will stop me if I start getting too much into discussion of policy, which hasn't been agendized. But I think the difficulty with that is that these tend to be so high that it's a really large expense, would require a building permit just to have the story poles possibly. It'd be difficult to just engineer one straight pole going up 35, 40 feet. Sometimes these are in... I do remember there was one previous case where it was brought up during discussion of should we have a story pole, and the commission at that point seemed satisfied to vote on the matter without having story poles. So we're kind of taking our cue from that as well. And a lot of these wireless facilities tend to be in areas where there already are antennas. Sometimes they're just relocations or co-locations, I should say. So we'll review those cases, and if they are, if there's something out there already that's substantially similar to what the proposal would be, we could let you know that. It would take a zoning code amendment to...
Yeah, I mean, I don't remember exactly the commission being against story poles. I think we had said it would be a good idea, and it just never, we didn't do anything. We said, I think that the discussion was, okay, then we'll put it to council or something like that. But I mean, if I'm wrong, you guys can talk about it.
You're right.
You're right.
Yeah.
I do remember real quick. Go ahead, Matt.
Yeah.
Let's see if there's a... But
Microphone.
we have so many of these antennas throughout the area, and there's, some of them have been very controversial, but in my history, I remember when they started, I was on the Parks Commission, and I look back and I see what's gone in, and I'm not happy with it. The industry will put in what we allow them to put in, so my thought is could there be some discussion, could we get some input about the poles that are disguised, whatever you call it? Camouflage. Is there some discussion we could have or some input we could have? And I just add that to Commissioner Sion's comment that it's about that whole issue. It's a good thought. I've been to some of these where you really couldn't tell. And then once it goes up, you look at it and you just didn't have a sense for it. So I think that's two items that could be discussed. I don't know how we put that on the agenda, but I would suggest that.
You talk about like monopine,
Yeah, pine or palm trees or whatever. And we've had some that are put into churches and such, and those are great because you don't see them, but it's a thought.
Okay, well, actually, what we could probably do is if maybe put together some discussion of some of these questions and agendize it as a study session item. As you know, the code gives the power to initiate zoning code amendments to the city council.
We could
I would be okay with
put some
that,
thoughts
yeah.
together and share them, move them forward.
Yeah.
That's okay.
Any more comments?
None.
Ready for
So moved. Move that we adjourn.
This is early.
so adjourn?
Thank you.
You can go for happy hour now.
That we're at this early.